Good morning, Deputy. Can you hear me?
Yes, Your Honor, I can hear you.
Guys, coming out. Come on, step out, ladies.
All right, I'm ready when you all are.
All righty, no problem. We're gonna set them up now.
Okay. You just let me know when you're ready, Deputy.
Yes, Your Honor.
Everybody go fall in. Hey, I need over here. Yeah, behind. Get it, one in the middle. 3 lines, guys. 3 lines. Ladies, go right here. 3 lines.
Muted too.
Go, sir. Let's go. Come on, go, man. Shit, you fighting here. Go. Wait, let's go. Let's go. Take all that gear off. We gonna rest up. Come on. Come on. Take these guys. Three lines. Stay over here.
All right, is everybody ready, Deputy?
Yes, Your Honor, everybody ready.
All right. All right, good morning, ladies and gentlemen. It is approximately 11:01 a.m. here on September 27th of 2025, and this is today's first appearance here in Clayton County. My name is Judge Marcus Thorpe. I'm one of the Associate Magistrate Judges here in Clayton County, and I'll be presiding this morning over your first appearance. Just a couple of things, ladies and gentlemen, that I'd like to speak to you all about that I hope will help things move smoothly here this morning. If you're having trouble hearing me, please let me know, as there are going to be, as I said, a few things here prior to the start of the calendar that will be very important that each and every one of you hear and understand. First and foremost, I am not here to try your case or take a plea or have any legal discussions about the specific facts of your case. The purpose of today's hearing is for me to inform you of what you've been charged with by the police, to set bond where I am able to set bond, to advise you of your rights, and then also to schedule a preliminary hearing, and then lastly, to appoint you an attorney if you qualify. Now, ladies and gentlemen, each of you has the right to remain silent. Please do not attempt, as I said, to tell me specific facts about your case or any legal defense that you may have. This is live. This is being recorded. If you were to do so, you not only make myself, but also the deputies around you and those other individuals that are in custody at this time, potential witnesses to your case. Now, in addition to the right to remain silent, each of you also has the presumption of innocence. You have the right to an indictment by grand jury for felonies or by accusation for misdemeanors. You have the right to a speedy and public trial by jury. You have the right to compel the attendance of witnesses to testify on your behalf. You have the right to see, hear, and question witnesses who are called to testify against you. You have the right to testify on your own behalf or offer evidence in your own defense. You have the right to an attorney to represent you. And if you cannot afford an attorney, I have the ability to appoint one for you if you qualify. And then lastly, if there are any individuals here today who are not citizens, please keep in mind that some of these charges may adversely affect you. And so my strong advice would be to please speak to an immigration attorney after the conclusion of today's hearing. Now, in addition to advising you of what you've been charged with, again, one of the things I mentioned is that I will also tell you what your bond is. The bond is an amount that you as an individual will pay, not to close your case or to end your case, but that allows you to be out until your next court date. There are 3 ways to make bond. You can either pay that bond in cash, in commercial use of a bonding company, or through property. Now, if you post a cash bond, the example that I like to use is what would happen is I would tell you, ladies and gentlemen, that you are charged with an offense of aggravated assault. I may tell you that your bond is $6,000. If you wanted to post it with cash, that means either you or someone you know would have to bring $6,000 down to the sheriff's office, along with any associated fees that the office will charge. And the sheriff will hold that money until your case is closed or dismissed. And then that money will be returned. The second way to make bond is the use of a commercial bonding company. And so that same example, if you're charged with aggravated assault, I tell you your bond is $6,000. However, you don't have that amount in full, you can use a bonding company. And a bonding company will typically charge you anywhere from 12 to 15% of your bond. But the big difference between a commercial bond and using it by cash is the money you pay a bonding company, you don't get that back. They keep that. That's their fee. And so in that example, 12 to 15% of $6,000 would roughly be about $750 that you would pay the bonding company. And then again, as I said, they would hold on to the rest. The final way to make bond would be the use of a property bond. And that is where you or either someone you know has 3 times the equity in their property as your bond is. So if your bond is $6,000, then either you or someone you know would have to bring a deed to their property down to the sheriff's office, but they would have to have $18,000, a minimum of equity in their property. Now, in addition to your bond, there are those of you all who this morning will have what are called special conditions. There will be people here this morning that I will tell you, based on what you've been charged with, that you are to either have no contact with the alleged victim or you are not to return to a particular place. If I tell you, ladies and gentlemen, that you are not to have particular contact with someone, don't do it. And that means don't email them, don't write them, don't text them, don't DM them, don't any sort of communication whatsoever. Don't even do something as simple as write them a song, as that would be a violation of this bond order and cause you to be rearrested and taken into custody, where you will then face additional felony charges and up to 20 years in prison and $20,000 in fines. Now, as I said, there are those of you all who I will tell you that you are now not allowed to return to particular places. If the place where the incident was alleged to have happened is a place that you were living at, again, ladies and gentlemen, you are not to return there. You are to speak to your attorney, and if something can be done to alter that bond, they will take care of that. But in the meantime, the only opportunity you have to return there would be within 10 days of your bond to contact the Clayton County Sheriff's Office. They will escort you there to get any items not in dispute and that belong to you. Otherwise, you are not to return because, again, you would be in violation of this bond order and subjecting yourself to additional charges. Now, ladies and gentlemen, that brings me to a couple other things before we get started. The first being there are at least a few individuals that I, as a magistrate judge, do not have the authority to give you a bond this morning. I will advise you of that. So I will give you not only your next preliminary hearing date, but I will tell you when your bond hearing date will be as well. If there's anyone here that is on active probation, I will also advise you of that and also advise you that I am not permitted to set bond for you. And then as well, give you your not only your preliminary hearing date, but your bond hearing date as well. That brings me to my last statement, and then we will get started. Preliminary hearings. Preliminary hearings, ladies and gentlemen, are hearings where you are present, the police officer that arrested you, as well as the judge. It is not your trial. It is a hearing where the judge reviews the evidence that the officer used to arrest you. And the judge will determine if, in fact, there is enough evidence for your case to move forward to the prosecutor. Okay? If you are charged with a misdemeanor, you have a right to a preliminary hearing. You don't have to have it, though. You could tell me this morning, Judge, I don't wish to have my preliminary hearing. Please go ahead, move past that, waive my right to my hearing. And what will happen is it does make your case move a little quicker. Or if you're charged with a misdemeanor this morning, you can tell me, Judge, I want my prelim. I would like to have you schedule it, and I will give you your next court date if you don't make your bond, because you only get that prelim if you're still in custody. If you are charged with a felony and you don't make bond, you have an automatic right to a preliminary hearing, and I will advise those of you all who are charged with felonies this morning when your preliminary hearing court date will be. With that, ladies and gentlemen, if I could have everyone please raise your right hand. Do you swear or affirm that the information you provided here this morning on the court-appointed counsel, as well as any information you will provide during the course of today's hearing, will be the truth and nothing but the truth, so help you God? And if you do, please say, I do.
I do.
All right, Deputy, whenever you're ready, if we could have the ladies in line, please.
All right, Boyd, you first. Buckler.
Hi.
Good morning, and I believe, are you Ms. Boyd?
Yes, sir, I am.
All right, Ms. Boyd, I have here with you charged with 1 count of misdemeanor fleeing from a police officer, 1 count of obstruction as a misdemeanor, 1 count of driving with a invalid registration, improper lane change, driving on the wrong side of the road, and improper passing. Is that correct?
Yes, sir, that's correct.
Okay, and so, ma'am, I've had an opportunity to review the information that was provided to me. I am going to release you here later today. Now, let me be clear, ma'am, that does not mean that your case is closed. It simply means that you are going to be out until your next court date, and you'll receive that in the mail, okay?
Okay, I got it.
And so when you are released later today, please make sure that whatever information the sheriff has on file as it relates to your case is the correct address. Because again, that's how you're going to get your next court date, okay?
Yes, sir.
Now, you do have special conditions, Ms. Boyd, in order for me to OR you. You're going to have to reside with your parents and or legal guardian. And then I'm also going to require that you be on a curfew until that's modified. So you are
Okay.
not allowed to be out anytime beyond 10 p.m. unless it's for an emergency once you are released. Do you understand that, Ms. Boyd?
Yes, sir, I understand.
Lastly, Ms. Boyd, I did review the information you provided. And based on the information that you provided, ma'am, you do qualify for a court-appointed counsel. And so you will, ma'am, have a attorney free of charge to assist you on your case. Do you understand that?
Yes, sir.
Wait, do you have any questions of me?
No, sir.
All right, ma'am, then that's all I have, ma'am. Good luck to you.
You were breaking up when you said the last part.
I said that's all I have for you this morning. I was telling you good luck to you.
Okay, thank you so much.
Thank you.
How do I call my mom that bail me out?
Dismiss us? Next, go ahead.
Are you Ms. Butler?
Yes.
Ms. Butler, I have here that you were charged with one count of misdemeanor simple assault, one count of misdemeanor simple battery, and one count of criminal trespass. Ma'am, the simple assault carries a bond of $2,500, the simple battery $2,500, and the trespass also for a bond of $2,500, leaving your total bond, ma'am, at $7,500. Do you understand that?
Yes.
You do have special conditions, ma'am, and they are to stay away from the alleged victim, Mr. Jaheim Jones, as well as from the address of 724 Indian Lake Drive. Do you understand that?
Yes.
Do you have any questions about anything, ma'am?
No, sir.
Now, as I mentioned earlier, you are charged with a misdemeanor, and so you have a right to a preliminary hearing, or you can waive that right to that preliminary hearing. Would you like to have it or waive it?
Waive it, please.
All right, so I am showing here that you are requesting that we waive your right to your hearing. So once we are done here this morning, ma'am, the deputies to my left and your right will have a piece of paper for you to sign, okay?
Okay.
Other than that, ma'am, the final thing I need to just discuss with you is that I did review the information that you provided here this morning. Unfortunately, you do not qualify for a court-appointed counsel, and so that means you will have to hire your own attorney if you wish to have one assist you, okay?
Okay.
All right, man. Well, that's all I have for you this morning, Ms. Butler. Good luck to you.
Thank you.
Thank you.
That's fine.
And are you Miss, is it Graciano?
That's correct.
All right, so Ms. Graciano, you were charged with one count of driving with a suspended license, ma'am. Your bond amount is $1,500. Do you understand that?
Yep.
I have reviewed the information that you provided this morning, ma'am. You do not qualify for a court-appointed counsel, so you will have to hire your own if you desire an attorney for your case, okay? Ma'am?
Do I qualify for this? They said that I qualify for a signature bond.
You do not today, ma'am. No, ma'am.
Do not?
No, ma'am.
All right.
Lastly, you have the right to a preliminary hearing, ma'am, or you can waive that right to the hearing. Would you like to have me set your preliminary hearing or waive your right to that hearing?
I'm not sure.
Okay, so again, just to give you a brief reminder, that hearing is where you're present, the judge is present, and the police are present, and they'll have to present the evidence that they have against you to determine whether your case will move forward or if it'll be dismissed at that level. If you choose to have it, I will give you that court date, but you'll only get it if you don't make bond, okay? That is not your trial. That's just where the judge is reviewing the evidence that they have against you. Or you could tell me, Judge, I don't want my hearing altogether. I'll waive my hearing, in which case you bypass it and your case does move a little quicker to the prosecutor.
Yeah, I'll waive it.
All right, so we are going to show that you are waiving your hearing this morning, ma'am. And the sheriff's office will have a piece of paper for you to sign. That's all I've got this morning, ma'am. Good luck to you. Thank you. I probably could have done it. Are you Ms. Harris?
I am.
Ms. Harris, you are charged with one count of misdemeanor criminal trespass, ma'am, and your bond amount here is $2,000. You do have special conditions, ma'am, and they are to stay away from the alleged place where this happened, that being 5390 Riverdale Road. Do you understand that, ma'am?
Yeah.
Do you have any questions about that? Okay. Now, you have the right, ma'am, because you were charged with a misdemeanor, to a preliminary hearing, or you can waive the preliminary hearing. Would you like to have that hearing or waive it?
It doesn't matter, you can choose.
Well, I can't do that, ma'am. So it's got to be your choice. We can either set that date or we can waive it.
We can waive it.
All right. So I am showing that you are asking that I waive the hearing. And so once we are done, ma'am, the deputies will have a piece of paper for you to sign. Okay.
Okay.
All right, ma'am. Well, that's all I have for you. If you would please step to your right for the deputies to sign that document, and you are good to go.
Hey, Your Honor, let me ask a question.
Yes, sir.
Do you want all the fugitives together last?
Say that one more time.
Do you want all the fugitives all together? Or you
Yes, please. I saw Miss Harris, I think was one of them. Or
Yes.
Miss Hicks.
Yeah,
Whichever
Ms.
one.
Harris.
Yes, Miss Harris. Yep. Can you put her with the two gentlemen, please?
All right. What's that right there?
All right. And is it Miss Hicks?
Miss Hicks right here. Character.
All right. So, Miss Hicks, you are charged with one count of misdemeanor obstruction or hindering of a law enforcement officer, and one count of misdemeanor simple battery on a police officer. The obstruction carries a bond of $2,500. The simple battery, $2,500, ma'am, for a total bond of $5,000. Did you hear that, Miss Hicks? Okay, so your bond, ma'am, again is $5,000. Because you are charged with a misdemeanor, Ms. Hicks, you have a right to a preliminary hearing, or you can waive that right to the hearing. Would you like to have that hearing or waive it, ma'am?
Well, I know the 2,500, you said both of them are missing?
Each one is, yes, ma'am, each is a misdemeanor, and your total bond is $2,500.
Okay, and you said the preliminary, that's with the judge and the officers, right?
Yeah, they're gonna review the evidence against you and determine if there's enough evidence for your case to proceed to the next level.
Okay, and you said if you do that, can I still post bond, or you said?
You can, ma'am. Even if I said it, you can still post bond, because if you post bond before the hearing date, your hearing just is waived.
Okay, and I think I want to do the preliminary.
Okay, so what I'll do is then we will go ahead and set the date. Your preliminary hearing date is going to be October 27th. That's going to be at 8:30 a.m. and that's going to be via Zoom. Again, that's going to be October 27th. That's at 8:30 a.m. and that's via Zoom. But as we just discussed, ma'am, if you are able to bond out, please remember that court date will be automatically waived, okay?
Wait, so if I am able to bond out, you said I won't get a chance to?
No, ma'am. If you bond out, that day is waived. No, ma'am.
Okay, I guess I don't know what the misdemeanor really means for my record. You know what I mean? I don't know.
Well, misdemeanor is just the severity of what you've been charged with. That's the difference. But I've gone ahead and set the hearing date for you. I think that's the best thing to do to protect you. But you, again, will only get that hearing if you don't bond out between now and the 27th of October.
My last question, if I bond out, I don't get the preliminary, but I still probably gonna have a court date, is what you're saying?
You're going to get a court date regardless. Yes, ma'am.
Okay,
You just won't get the
alright.
preliminary hearing.
Okay, all right.
Okay?
Yep.
All right. Good luck to you, ma'am.
Thank you.
Ms. Jones.
Next up should be, I have Jennifer Jones.
You probably got your
All right. Are you Ms. Jones? Ms. Jones, you were charged with 3 counts of violation of the Georgia Controlled Substances Act, 1 count of possession of marijuana less than 1 ounce, and 1 count of possession of drug-related objects. Each count of the VGCSA, ma'am, carries a bond of $3,500. The possession of less than 1 ounce, a bond of $1,000, and the drug-related objects carries a bond of $500. And so with that, ma'am, your total bond there is going to be $12,000. I have here, ma'am, the court-appointed counsel information. Are you currently working, Ms. Jones?
No, I'm not.
Okay. So based on that, ma'am, I am going to go ahead and appoint you a lawyer free of charge that will be able to assist you in your case. Lastly, Ms. Jones, would you like me to set the preliminary hearing date for you, or would you like to waive that hearing?
No, just waive it.
All right, so I am showing you are requesting a waiver, and so once we are done here, the deputies will have a piece of paper for you to sign. And Ms. Jones, unless you have any questions for me, we are done, ma'am.
Thank you.
Thank you.
Go ahead, Ms. Wood.
Give me 1 second, man. All right, and are you Miss Wright?
No,
What's your name, ma'am?
Worthy, Lee
Oh.
Worthy.
Yes, I apologize. I got out of order. Yep. All right, so Ms. Worthy, you are charged with one count of violation of a Georgia Controlled Substances Act, ma'am. That is a felony. Your bond amount is $3,500. Your preliminary hearing date, ma'am, should you not make your bond, is going to be October 28th. That's going to be at 8:30 a.m. and that will be via Zoom. Do you understand that, ma'am?
Yes, sir.
Ma'am?
Yes, sir.
Okay. Now, as far as your ability to have court-appointed counsel, I did review the information that you provided this morning. You do qualify for court-appointed counsel, and so you will have an attorney free of charge to assist you on your case, okay? Can you hear me?
Yes.
Okay. Do you have any questions for me, ma'am?
No.
All right, ma'am, then we are done. Good luck to you. And then now should be Miss Wright. And are you Miss Wright?
Yes, sir.
Ms. Wright, you are charged with one count of improper lane change, one count of possession of marijuana less than 1 ounce, one count of felony drugs, and one count of possession of drug-related objects, ma'am. Your bond amount is $5,500 total. Now, because you are charged with a felony, ma'am, you do have a preliminary hearing date set of October 28th at 8:30 a.m., and that will be via Zoom. Again, that's October 28th. That is at 8:30 a.m., and that is via Zoom. Do you understand that?
Sir.
Now, lastly, based on the information that you provided, ma'am, you do qualify for a court-appointed attorney. And so I have gone ahead and appointed you an attorney free of charge to assist you on your case, okay?
Thank you, sir.
Yes, ma'am. Good luck to you. Oh.
Tell my front 5,000.
Yes, ma'am. Well, let me just confirm again there. 5,500. 5,500. Yes, ma'am.
Okay, appreciate it.
All right, thank you.
Gotcha, come on. All right, these are your 3 fugitives, Your Honor.
Okay, so I was just gonna handle them at the end after we get through the men. Did you want to do them first?
Yeah, I wanted to finish with the last female, so that all the females can go back.
Sure, no problem. Give me 1 second here. And you are Miss Harris, is that correct?
Yes, sir, Your Honor.
Okay.
Yeah.
All right, so I'm gonna speak up so everybody can hear me, even those of you all in the back. So lady, and then gentlemen, you all have a different situation than what everybody else has. You all were arrested here in Clayton County, not because you have new charges, but for charges that each of you have stemming from something that happened in another county. As an example, I think 2 of you all have charges from South Carolina, and then Ms. Harris, I believe yours are from another state, from Mississippi. Now, I want to talk to you all each individually after I sort of give you the lay of the land of where we are. Now, each of you has the opportunity, now having been arrested for these outstanding warrants, to do one of 2 things. All right. I'm going to advise you of what their warrant is that's got you on hold, and then you're going to tell me what you'd like to do. You're either going to say to me, Judge, I don't think that the procedure that the other place used, the place where I've got the warrant at, is correct. Therefore, Judge, I would like to challenge the procedure that they used. Okay. If you tell me that that's what you want to do, the law here in the state of Georgia gives them up to 90 days to come down and have a hearing. That means you would sit in custody for 90 days. If after that time it's not resolved, your hearing doesn't happen, they get an additional time frame as well of, I believe it's 30 days, to then still, again, have that hearing. If they don't come down in that time frame, Clayton County will release you. All right, so option number 1 is you want to fight the procedure. You're not fighting the underlying facts. We're not going to talk about the facts of your case. It's just a procedure. Option 2 would be you tell me, Judge, I don't want to stay in Clayton County. I would rather you send me back to where the outstanding warrant is. And if that is the case, we will have documents for you to sign here this morning. And once those documents are signed, the sheriff's office will contact the place where you have the outstanding warrant, and they will come pick you up. Okay? So Ms. Harris, if you want to step up a little so you can make sure you hear me. So, Ms. Harris, as I mentioned earlier, you are charged with having an outstanding warrant out of the state of Mississippi. It looks here for credit card fraud that they have put out the warrant on for you. Again, you got the option, ma'am. You can fight the procedure in which, again, you will remain here until your hearing is held, or we can simply go ahead and extradite or send you back to Mississippi where you can fight the charges. What would you like to do, ma'am?
Send me back, please.
Okay. So then what's going to happen, as I mentioned earlier, the deputy is going to have, it's going to be about 5 or 6 pages. It's going to look exactly the same. But once you sign those, ma'am, we will go ahead and get the process started to sending you back, okay?
Yes, sir.
All right, thank you, ma'am.
Thank you.
All right, if I could have, I believe it's Mr. Hightower.
Oh, one. You sign all
Hey,
of
Your Honor, how you doing?
I'm doing well, sir. How are you?
Oh, well, you don't gotta read. Charge.
And so, Mr. Hightower, same situation. Your warrant is out of South Carolina. You've got that same option. We can either allow you to remain for the procedure or send you back.
I'm gonna just go.
Okay.
Talk to
All right. So I am showing that you are requesting that we extradite you back or begin the process to extradite you back to South Carolina. Thank you very much, sir.
Thanks, sir.
And then I believe is it Mr. Valmore, Valmor?
Take that and sign it. Come on, Belmont. That's how you doing, Your Honor.
Good morning, sir. So, Mr. Valmore, same thing to you, sir. You have that option to either remain. Your warrant is also out of South Carolina. Yours is out of Columbia. Or we can begin the process to send you back to South Carolina. How would you like to proceed?
Send me back.
All right, sir. So I am showing that you are requesting to be sent back as well. Thank you.
I have one question.
Yes, sir.
What is the time limit they have to come and get us?
30 days to come get you. Otherwise, they will release you.
All right.
Thank you.
Hey, give me the first 5. Character. Oh, what do you got?
While they're doing that, any questions so far?
Character's gonna take that back right now.
That was him just now.
Provide those orders, because you moved really quickly.
You talking about the extradition orders?
Yeah.
No, they send them back to me. It's on.
Oh, okay, so you don't, okay.
Are you Mr. Barnes?
Bail.
Oh, Bell. Okay. See how they got in the order. All right, so Mr. Bell, you are charged with 1 count of rape, 1 count of felony, 1 count of misdemeanor sexual battery. Sir, sexual battery carries a bond of $10,000. The rape, sir, I am not permitted to grant you bond this morning, so you are on a no bond status. You do have special conditions, sir, if you are granted bond at a later date. Those being, you are to stay away from the alleged victim, that being Kenesha Whipple, Whipple.
Hey, quiet.
Also to stay away from the address of 5751 Riverdale Road. Do you understand that, Mr. Bell?
Yes.
Now, Mr. Bell, I've had an opportunity to look at the information that you provided this morning. I have gone ahead and appointed you court-appointed counsel, so you will have an attorney free of charge to assist you on your matter. Do you understand that?
Yes, sir.
Do you have any questions for me, sir?
No, sir.
All right, sir. Good luck to you.
Thank you.
Thank
Let me check, hey, let me tell you something, girl.
And are you Mr. Barnes?
Yes,
I'm sorry?
Yes, I am.
All right, Mr. Barnes, you were charged with 2 counts of obstruction, 2 counts of simple battery on an officer, 1 count of tampering with evidence as a misdemeanor, 1 count of possession of a firearm during the commission of a crime, and 1 count of possession of a gun by a convicted felon. Each of the obstructions carries a bond amount of $2,500. Each of the simple batteries on an officer carries a bond amount of $5,000. The tampering bond amount is $2,500. The firearm possession by convicted felon is a bond amount of $8,000. Now, the possession of a firearm during the commission of a crime, sir, I did review the information that we have here about that, and I have made the decision to dismiss that warrant. The remaining charges that you have, sir, your bond amount on those, however, is $25,500. Do you understand that?
Yes, sir.
All right. Now, because you are charged with a felony, sir, after your preliminary hearing, your next court date is going to be October 28th, should you not make your bond. Do you understand that?
Yes, sir.
And then lastly, Mr. Barnes, based on the information that you provided here this morning, sir, I am going to go ahead and appoint you a court-appointed lawyer, so you will have a lawyer free of charge to assist you on your case. Do you understand that?
Yes, sir.
All right, sir. Well, if you don't have any questions for me, sir, you are free to go.
No, thanks.
Thank you. All right, are you Mr. Bibbs?
Yes.
Mr. Bibbs, you are charged with one count of false report of a crime, sir. Your bond amount is $2,000. This is a misdemeanor charge, sir, which means you have a right to a preliminary hearing, or you can waive your right to that hearing. Would you like to have the hearing or waive it?
I'm not sure what to do, so I guess I have to, I'm not sure.
So to protect you, sir, I'm gonna go ahead and set that hearing. I don't want you to lose that right. And then later you realize that you did want to have it. Your next court date, sir, should you not make your bond, is gonna be October 27th. It's gonna be at 8:30 a.m. and that's gonna be via Zoom. Again, that's October 27th, 8:30 a.m. and that'll be via Zoom. Do you understand that?
I understand.
Do you have any questions of me, sir?
No, sir.
All right, good luck to you, sir.
Grab your peanut butter sandwich.
Should be Mr. Blake. Are you Mr. Blake?
Yes, sir.
Mr. Blake, you are charged with one count of criminal trespass as a misdemeanor, one count of obstruction as a misdemeanor, one count of disruption of public school, and one count of loitering at a school property. The obstruction carries a bond amount of $2,500, as does the other charges. So your total bond is $7,500. I have, sir, however, dismissed the one count of criminal trespass. Do you understand that?
Yes, sir.
Mr. Blake, you do have special conditions, and they are to stay away from 9652 Fayetteville Road. So you are not allowed to return to the school property. Do you understand?
Sir.
Lastly, because you are charged with misdemeanor, sir, you have a right to a preliminary hearing, or you can waive your right to the hearing. Would you like to have the hearing or waive it?
I like to have it.
All right, sir. So your next court date, should you not make your bond, is going to be October 27th. That's going to be at 8:30 a.m. and that's going to be via Zoom. Again, that's October 27th. That is at 8:30 a.m. and that's via Zoom. Good luck to you, sir.
Thank you.
Thank you. All right, are you Mr. Cameron?
Yes, ma'am. Yes, sir.
Mr. Cameron, you are charged with one count of rape, one count of cruelty to children in the first, one count of child molestation, one count of sexual battery, one count of aggravated child molestation, one count of stat rape, and one count of enticing a child for indecent purposes. Now, these are all felonies, sir. Based on the information that I have here, sir, a combination of things. One, I am not allowed to make a decision on the bond as to whether you get bond on the rape charge, so you are no bond status on that. For the remaining charges that I am permitted to make a bond on, I have decided to make the decision to no bond you on those. The special conditions, sir, are that you are to stay away from the alleged victim in the matter as well. Do you understand that?
Yes, sir.
Do you have any questions about anything, sir? Sir, can you hear me?
No, sir.
Okay. Now, lastly, is we need to just discuss your court-appointed counsel paperwork. I did have an opportunity to review that, sir, and I have gone ahead and appointed you court-appointed counsel. So you will get counsel free of charge to assist you. Do you understand?
Yes, sir.
So a couple court dates I need you to remember. Again, because you are charged with a felony, your next court date is going to be on the 28th at 8:30 a.m. via Zoom. Then, because you are on a no bond status, your second court date will be October 31st, also at 8:30 a.m. and also via Zoom. Do you understand?
Yes, sir.
All right, good luck to you, sir. Next up should be Carson. All right, are you Mr. Carson?
Yes, sir.
Mr. Carson, you are charged here with one count of misdemeanor battery. Your bond amount, sir, is $3,500. You do have special conditions, sir, and they are to stay away from the alleged victim here in this matter. That is a Miss Kimberly Hall. Do you understand that, sir?
Yes, sir.
You are also to stay away from the address of 6042 North Lee Street here in Jonesboro. Now, because you are charged with a misdemeanor, Mr. Carson, you have the right to a preliminary hearing, or you can waive that hearing. Would you like to have the hearing or waive it?
Have it.
All right, sir. So I am showing that you are requesting your hearing. So your next court date, should you not make your bond, will be October 27th. That'll be at 8:30 a.m. and that'll be via Zoom. Again, that'll be October 27th at 8:30 a.m. and that will be via Zoom. Now, as a court-appointed counsel, sir, I have reviewed the information that you provided this morning. You do qualify for a court-appointed counsel, so you will have counsel free of charge to assist you, okay?
Okay.
All right, good luck to you, sir.
Thank you.
Thank you.
You know what, second, go
Next
stand right
up to be Edge, and then after Edge, Esther. Are you Mr. Edge?
Yes, sir.
So, Mr. Edge, you are charged here with one count of misdemeanor battery as well. Your bond amount is $5,000, sir. You do have special conditions, and they are to stay away from Kenneth Yancey and from the address of 1577 Pintail Road. Do you understand that?
Yes, sir.
Now, because you are charged with a misdemeanor, sir, you do have a right to a preliminary hearing, or you can waive your right to that hearing. Would you like to have the hearing or waive it, sir? I'm sorry?
Have it.
All right, so I am showing, sir, that you are requesting that you had set your preliminary hearing date. And so your next court date, sir, is going to be October 27th at 8:30 a.m. and that will be via Zoom. Again, that'll be October 27th, 8:30 a.m. and that will be via Zoom should you not make your bond, okay? Do you have any questions of me, sir?
No, sir.
All right, good luck to you, Mr. Edge.
Mr. S, grab your side.
And it should be Esther.
Get it out, man. We're gonna get out one.
Yeah, that's.
All right, are you Mr. Esther?
Yes, sir.
Mr. Esther, you are charged with one count of brake lights, failure to use brake lights, 2 counts of violation of Georgia Controlled Substances Act as a felony, and possession of less than 1 ounce of marijuana. The brake lights carries a $500 fine, the marijuana $1,000, and the 2 felony drugs $3,500, sir, for a total bond of $8,500. Now, because you are charged with a felony, sir, if you do not make your bond, your next court date is going to be the 28th of October at 8:30 a.m., and that will be via Zoom. Again, that will be the 28th of October at 8:30 a.m., and that will be via Zoom. Now, lastly, sir, I have reviewed the information that you provided on your court-appointed counsel sheet, and based on the information you provided, you do qualify for a court-appointed lawyer, okay? All right, good luck to you.
My bad.
Say that one more time.
I was saying, yes, sir. I had said my bad, so I apologize.
Oh, no worries, no worries. I appreciate it, sir. You enjoy the rest of your day.
You too.
Okay.
Some people choose to lie with the blood.
Are you Mr. Johnson?
Yes, sir.
Mr. Johnson, you are charged here with 1 count of possession of marijuana less than 1 ounce, 1 count of drug-related objects, and then 3 counts of felony drugs.
Wow.
Each count of felony drugs, sir, carries a bond amount of $3,500. The less than 1 ounce of marijuana, $1,000, and the drug-related objects, $500. So, sir, you have a total bond of $12,000. Do you understand that?
Yes, sir.
Now, because you are charged with a felony, sir, your next court date, should you not make your bond, is going to be October 28th, and that's going to be at 8:30 a.m., and that's going to be via Zoom. Again, that's October 28th at 8:30 a.m., and that will be via Zoom. Now, I have reviewed the information that you provided here today, sir, and based on the information you provided on your court-appointed counsel sheet, you do not qualify for a court-appointed counsel. And so, Mr. Johnson, you will need an attorney if you desire to have someone assist you on your case that you pay for out of pocket, okay?
Yes.
All right, sir, any questions?
You said about buying out, I'm gonna need to get my own counsel.
Yes, sir, you will have to hire your own.
Okay.
All right, good luck to you, sir.
And you said 12,500, right?
Yes,
Thank you.
That's the one.
thank you.
Go. Yeah, just gonna get your side.
No.
Clerk, in the camera. Arms out your sleeves. Go ahead, get ready.
All right, give me one moment, sir. And is it Mr. Khalik? Is that correct?
Yes, sir.
Mr. Khalik, you are charged with 1 count of driving without a tag, 1 count of drug-related objects as a misdemeanor, and 2 counts of felony drugs. The first count of felony drugs carries a bond amount of $3,500. The second, $10,000. The drug-related objects, $500, and the no tag, $500 as well, sir. And your total bond amount is $14,500. Now, because you are charged with a felony, sir, your next court date will be your preliminary hearing date if you don't make your bond. That court date is going to be the 28th of October, and that's going to be at 8:30 a.m. and that will be via Zoom. Again, that will be the 28th of October, and that will be at 8:30 a.m., and that will be via Zoom. Now, I did review the information you provided this morning on your court-appointed counsel. You do not qualify for an attorney, so you will have to hire your own, okay? All right, good luck to you, sir.
Thank you. No, it don't.
All right, now I've got Terry, Wilkes, and Williams. Terry, Wilkes, and Williams.
Wilson Williams.
Should be Terry, then Wilkes, and then Williams. Are you Mr. Terry?
Yes, sir.
Mr. Terry, you are charged with 1 count of cruelty to animals as a felony and 2 counts of terroristic threat, sir. I have reviewed the information, sir, and you are, according to what I have here, currently on probation out of Clayton County. And so I am not permitted by law to grant you bond. So you're going to have 2 upcoming court dates. Your first court date is going to be your preliminary hearing, sir, on the 28th of October at 8:30 a.m., and that will be via Zoom. Your second court date is going to be the 31st of October, and that's going to be at 8:30 a.m., and that will also be via Zoom. Mr. Terry, are you currently working?
No, sir.
All right, so then based on that, sir, I am going to be able to appoint you a court-appointed lawyer. So you will have a lawyer free of charge to assist you on your case, okay? You heard me there, Mr. Terry?
Yes.
All right, sir. That's all I've got for you. Thank you.
Put your hands behind your back, sir.
And are you Mr. Wilkes?
Yes, sir.
Mr. Wilkes, you are charged with 1 count of possession of less than 1 ounce of marijuana. Your bond amount here, sir, is $1,000. Looking at the information I was provided, sir, you do qualify for a court-appointed counsel, so you will have an attorney free of charge. Lastly, because you are charged with a misdemeanor, sir, you have the right to a preliminary hearing, or you can waive that right to the hearing. Would you like to have the hearing or waive it, sir?
Yes, sir.
I'm sorry?
Yes, sir. Yes.
You want to waive it? Okay. So I am showing that you are asking that we waive your hearing this morning. And so once we are done, the deputies to my left and to your right will have a piece of paper for you to sign, okay?
No, I was saying I didn't want to waiver it. I
Oh,
was
you
saying,
did not? I apologize. Yes, sir. If I misheard you. You were very soft-spoken. So your next court date is going to be October 27th, and that's going to be at 8:30 a.m., and that's going to be via Zoom. Again, that's going to be October 27th. That's going to be at 8:30 a.m., and that will be via Zoom. Do you understand that?
October 27th. All right, gotcha.
Yes, October 27th, 8:30 a.m., and that will be via Zoom. And that will only be if you don't make your bond, okay?
All right. You said my bond is 1,000, right?
Yes, sir, $1,000.
It's all right. Yes, start working.
All right, good luck to you, sir.
Thank you.
Thank you.
Grab a sec, sir.
Williams, Woodall,
Sorry.
Williams and Woodall. I think so. Are you Mr. Williams?
Yes, sir.
Mr. Williams, you are charged with 1 count of driving with a suspended license, 1 count of failure to use a signal when making a turn. You are charged with 4 counts of felony drugs, 1 count of misdemeanor open container, and 1 count of misdemeanor possession of a drug-related object. The no license carries a bond amount, sir, of $500. The open container carries a bond amount of $500. Drug-related objects carries a bond amount of $500. I did grant bond on 1 of those counts of felony drugs at $2,000. The remaining felony drugs, other 3, I have placed you on a no bond status at this point, sir. Do you understand that?
Sure.
I'm sorry? Okay. Now, because you are charged with a felony, sir, I'm going to give you 2 court dates. Your first is going to be your preliminary hearing. That's coming up on the 28th of October at 8:30 a.m., and that'll be via Zoom. Then your next court date is going to be for that bond hearing to reconsider bond. And that will be on the 31st of October. And that will also be via Zoom. Do you understand that, sir? So again, you're on a no bond for the felony drugs. You've got 2 court dates coming up. The first is going to be on the 28th, the second on the 31st, okay? All right, sir. That's all I have for you. Good luck to you.
What about the public defenders?
Oh, I'm sorry. I apologize. I didn't tell you. I did appoint you a public defender, sir. So you do have court-appointed counsel.
Thank you.
Thank you. And then are you Mr. Woodall?
Correct.
Mr. Woodall, you are charged here with one count of aggravated assault by strangulation and one count of simple battery family violence. The simple battery carries a bond amount of $5,000. The aggravated assault by strangulation carries a bond amount, actually, we placed you on a no bond status this morning. And so you will not have a bond on that. Do you understand that?
Why is that?
Because we made the decision to not put a bond on you, sir. It is within our discretion to do so.
Gotcha.
As to your special conditions, sir, you do have special conditions, and they are to stay away from the alleged victim. I believe it's your sister here, is what the warrant says, Tahilia Island. And you were also to stay away from the address of 6047 Twin Creeks Court. Do you understand that?
There anymore.
Okay, I understand, but you still gonna have to stay away from that address. Do you understand? Mr. Woodall?
Right.
Now, I have reviewed the information you provided, sir. You do qualify for a court-appointed counsel, so you will get counsel free of charge. You've got 2 court dates coming up. Your first court date is going to be your preliminary hearing, and that'll be at 8:30 a.m. via Zoom. Your second will be your bond hearing date to reconsider bond for you. That will also be at 8:30 a.m. via Zoom, but that will be on the 31st of October. Do you understand that?
Yes.
Do you have any questions, sir, before we conclude?
No.
All right, sir, and that's all I have for you, sir. Good luck to you.
That was thanks, sir.
All right, Judge, that's everybody.
All right, thank you so much, gentlemen.
All right, thank you.
All right, bye-bye.